Hello viewers, today we will discuss about the development of legal education in India. Legal education is essentially a multidisciplined, multi-purpose education which can develop the human resources and idealism needed to strengthen the legal system. A judicial officer, a product of such education, would be able to contribute to national development and social change in a much more constructive manner. Legal education provides the basic framework for the legal structure of any country. The significance of legal education cannot be overemphasized in a democratic welfare society like that of India. The study of law aims at serving as a medium to achieve socio-economic development. In the current scenario, law is not only viewed as a yardstick of social control, but also as that of social change. With this changing role of law in society, lawyers are also being considered as social engineers who are equipped with the skill that can help them in performing multifarious jobs in the society. So, the main aim of the legal education is to bring out lawyers with social vision. In contemporary developing nations aspiring to transition into social welfare states, there exists a close relationship between law, legal education, and development. These societies aim to improve the socio-economic status of their citizens through peaceful methods. The idea of legal education is expansive and all-encompassing. It includes more than the profession practiced in the court. It encompasses law teaching, law research, administration in different fields where law plays an important role, along with commercial and industrial occupations where legal knowledge and skill is required. It is ironical that in a country like India, where the development of science, agriculture, medicine, engineering, literature has assumed a considerable dimension of improvement, legal education in comparison has not attained so much importance. Now we will focus upon the scenario which was existing before independence as far as legal education was concerned. In the pre-independent India, legal studies was not considered to be a serious exercise. No doubt we can think about many legal luminaries in the freedom struggle of India who participated actively. However, the quality of legal education was not the reason for the same. During that particular period, the main objective of legal education was to train students to aid both lower and higher courts in delivering justice, either by registering as vakils or pursuing roles as judicial officers, all with the purpose of serving the interests of the administration. Moreover, under the colonial rule, there were only few courts in the country. The highest appellate court sat in England, and the top legal positions were the preserve of the British barristers. You must have heard about laissez-faire. It was the prevailing dogma at that time. The government was more in the nature of a police state rather than a welfare state, and the focus was only on the teaching of traditional law subjects. The opportunities available to the lawyers were quite limited at that time. One was expected to go to England to acquire bar at law, as much more prestige and social status was attached to this qualification rather than mere LLB from an Indian university. In view of Professor Arthur von Mehrin, before independence, the Indian legal profession and legal education had not developed a rationally functional approach to the problems of law and legal order, and the Indian legal education inevitably tended to evolve in patterns that emphasized rote memory. To impart information, not critical understanding, remained the goal of the legal education. Consequently, when India gained independence, its legal profession and legal teaching were thus not able to play the role they ought by Western standards to have played. Now, we will focus upon legal education and the scenario after independence. There were many attempts which were made immediately after independence for enhancing the standard of legal education, and the committee was headed by Radhakrishnan and was constituted, and it lamented over the pitiable and unsatisfactory condition of legal education with the comment that India had no internationally known expounders of jurisprudence, and legal studies in our colleges of law did not hold a place of high esteem. After that, University Grants Commission was set up in 1956, and this also pointed towards the existing dissatisfying scenario of the legal education in the country. It further suggested reorganization of law colleges and concentration on law as a single degree course. It was anticipated that this will perform a dual function of producing both lawyers along with legal scholars. The commission helped the University of Rajasthan to organize a seminar on legal education at Kasauli in 1964. The commission then set up the Legal Education Committee in 1970s. This committee decided to hold a seminar on legal education in India, Problems and Perspectives, which was held at Pune University from February 28 to 24. Then the UGC organized during 1975 and 1977 4 regional workshops on legal education at Madras, Chandigarh, Pune and Patna. The UGC also helped law faculties in various other ways by creating vacancies, grant for libraries, providing fellowship for research, etc. In 1958, the Law Commission of India gave its 14th report on the status of legal education in India. It came out with the issue that most of the students who are enrolled in these institutions are young men who have not been able to secure employment. They opted for the law course while waiting for the job with no intention of practicing law as a profession. The commission also observed that law had not been looked upon by the universities as an educational or cultural subject. The system awaited a major change in the legal education and technique by which it was imparted. The Law Commission made a series of 31 recommendations in its report on legal education as well as on the legal profession, including an all-important recommendation for holding an entrance test for admission to the law course. This report of the Law Commission was discussed at the All India Lawyers Conference organized by the Committee on Legal Education in March 1959, which resolved, departing from the recommendation of the Law Commission for the 3-year degree program in law, the most significant step that accelerated the progress of legal education in India was the establishment of Bar Council of India under the Advocates Act of 1961. It not only aimed at promoting legal education, but also laid down standards for streamlining legal education in India. It envisioned a standardized legal education system, with the Bar Council of India introducing a 3-year law course in 1967. This course was designed to grant a law degree after 3 years of study to individuals who were already graduates, regardless of their field of study, whether in science, arts or commerce. The law graduate could then join the profession by registering their name in the rolls of any state bar council. In 1982, BCI adopted another regulation on legal education that proposed 5-year LLB course after 10+2. It stipulated a pre-law course consisting of non-legal subjects like politics, economics, sociology, history and language. The important change in the remaining years of teaching legal subjects is the inclusion of subjects like administrative law and public international law as compulsory subjects. These rules were intended to improve standards of professional legal education. In 1986, the Bar Council of India, with a view to standardize legal education, thought of an archetype law school of international standards sponsored by it. Consequently, the National Law School of India University, NLSIU, located in Bangalore and sponsored by the Bar Council of India, was founded in 1986 through legislation enacted by the state legislature. The university embarked on pioneering a 5-year integrated law program. This course has demonstrated its superiority in legal education wherever it was honestly implemented. It can be said that it paved the path for the way for scientific evolution of legal education, serving as a model to be emulated across the country. Although Bar Council of India had initiated the 5-year law course, it could not totally prevent the existence of 3-year law courses. The 3-year law program was predominantly offered in numerous law colleges as a part-time program, with classes held in evening. Many of these colleges did not have even a single full-time faculty. The members of the bar councils, universities, University Grant Commission and state government met at Bangalore in 1996, and in this meeting they collectively accepted that there is need to bring out uniformity in the syllabus of law courses offered across the country. Subsequently, they also focused on the catalogue of subjects necessary to be imparted to a legal professional for the future. The meeting consequently outlined 24 subjects to be taught as compulsory and an additional 6 optional subjects which universities could select based on local requirements and professional relevance. Following recommendations from a 1996 meeting in Bangalore, the Bar Council of India in 1997 ultimately suggested 21 compulsory legal papers, along with 4 mandatory practical training papers and 3 optional papers. Thus, a new approach was adopted towards the development of legal education in the country. On the behest of the University Grants Commission and the Bar Council of India, number of changes were introduced in the syllabi so as to incorporate practical training component into the law school curriculum. And that was accomplished by introducing clinical legal education in the country. The term clinical legal education refers to learning by doing types of things that lawyers do. It allows the students to take on real clients' problems and work with them with the obvious goal of equipping the students to perform the variety of roles which the lawyers are expected to play within the society. It is a system designed to facilitate the students to learn the 15 laws through experience and directs the students to make an attempt to comprehend the theoretical and operational parameters of legal doctrines and statutory principles and the techniques of applying them in actual practice and real life situations. The most remarkable initiative as extended by the Legal Education Committee was the establishment of national law schools, which truly became the developmental ground for legal education in India. These institutions were the top-class law colleges having excellent infrastructure and facilities. National law schools were created to provide innovation, experimentation, and pursuit of excellence in the stream of legal studies. These institutions were started as an experimentation process but have contributed to setting up the benchmark of the quality of legal education throughout the country. Through its statutory authority and responsibility of ensuring standards in professional legal education under the Advocates Act 1961, the Bar Council of India had to take the decision for establishing national law schools in India. These schools constitute a very good example of cooperation amongst all the 3 wings of the legal profession: bar, bench and law academics. The Chief Justice of India is the visitor of the law school. The Chairman of the Bar Council of India is the Chairman of the Governing Council of the school. The objects of the school, however, are not limited to preparing conscientious, competent members of the profession, though it remains its basic mandate. The school is expected to advance and disseminate knowledge of law and legal process in context of national development. In other words, the school shall endeavour to look at law as an instrument for social change and human well-being. The major focus of the school's curriculum necessitates the study of law from broader socio-cultural perspective and developmental goals. In the discourse surrounding the establishment of national law schools, divergent opinions have emerged. Advocates argue that these institutions are crucial for ensuring the relevance of legal education within society. They stress the importance of maintaining academic independence, implementing innovative teaching approaches, and updating curricula to align with contemporary policy shift. On the contrary, S.P. Sathi, in his work Is a National Law School Necessary?, questions the necessity of national law schools, contending that they foster elitism, primarily serving the interests of a privileged minority. Sathi, as early as 1974, anticipated that only students from affluent backgrounds would have access to these institutions. He suggests that efforts should be directed towards enhancing legal education more broadly rather than focusing on exclusive establishments that benefit only a selected few. He calls for greater involvement from the Bar Council and urges the central and the state governments as well as the University Grant Commission to bear the principal responsibility for improving legal education. The National Knowledge Commission was constituted in June 2005. It pondered over the standard and quality of legal research and education across the nation. It also looked into the strategies for overhauling the system towards achieving academic and professional excellence. On the suggestions of the National Knowledge Commission, the University Grants Commission appointed an expert committee in 2010, which later submitted a comprehensive report, and the UGC promptly implemented one-year LLM degree course in India from academic session 2013 to 14. Since then, there has been no looking back. In 2010, Curriculum Development Committee was constituted with the efforts of the Bar Council of India. It emphasized the autonomous role of faculty in conducting and designing the courses in the universities. It further emphasized that the institutions should make a collaborative effort in harmonizing the curriculum and developing the strategy of teaching learning based on the local needs and resources available. Besides, it also focused on the lack of qualified faculty and emphasized on the necessity for national law schools to focus on faculty development programs. Many scholars have analyzed the challenges of the legal education. There is a growing recognition of the importance of highlighting the interdisciplinary approach to legal education. The present educational methods and priorities ought to be revised as they fail to provide the teamwork, practical and empathetic skills that are necessary in practice. It is imperative to create awareness about the challenges being faced by the society in present times. And this consists of the difficulty and expense of obtaining justice, unfulfilled legal demands of various social groups, the effects of globalization on human rights and equality, significant advancements in information and communication technology, the state's relative helplessness due to market dominance, and the role of profession in promoting justice, peace, and development. Traditionally, a lawyer's job is to show up following an incident, settle the dispute, and give the injured party justice. The current scenario envisions additional roles such as policy planner, business advisor, expert in idea articulation and communication, mediator, lobbyist, law reformer, and negotiator amongst interest groups. All of these positions require specialized knowledge and abilities that are typically lacking in the field in which they are employed. Still, it is essential to implement change. It is crucial that the legal profession exists to promote public welfare, not the other way around. NEP 2020 is the vision document which proposed an inclusive and equitable education to achieve socio-economic justice. Para 20.4 of NEP specifically deals with legal education. It laid stress on multidisciplinary learning concerning curriculum and use of technology for quick justice delivery. A need was also expressed to translate good law books into the local language to make legal education more inclusive. Keeping in view the use of local language in the law courts, emphasis was also laid on promoting bilingual teaching in the law colleges. So, after going through the entire discussion, we have understood that the legal education is a study and research in the field pertaining to law, and we have also learned about the significant landmarks and efforts which are involved in the development of legal education in India. However, we must know that as far as formal legal education is concerned, its objective is to create professional lawyers. As far as non-formal legal education is concerned, its objective is to train and discipline the mind of the community of people to promote consciousness of legal rights and responsibilities. Non-formal legal education not only aimed at awarding academic diplomas, but to adopt a series of training methods to take law to the people in order to equip them to assert their legal rights which they are deprived of. In a country like India, where majority of the population is illiterate and ignorant about law, our lawmakers have deliberately based the rule of law on the lopsided principle of ignorantia juris non accusat. 6 of which means ignorance of law is not an excuse. This maxim will continue to be meaningless unless the state steps in to provide legal knowledge to all its people. The present law courses are too academic and doesn't suit the needs of non-formal legal education. It is thus realized that the legal education, in order to be effective and productive, should keep pace with the changing needs of the society. Justice P. N. Bhagwati rightly pointed out that a constitution proclaims equality before law, but with a large million of population, equality before law remains merely a myth or an illusion. So, until and unless we ensure non-formal legal education to the poor people and also provide them with the facilities to approach the courts for justice, we cannot claim that the poor people are also getting equality before law and equal protection of law. There is a need to streamline the legal education imparted, keeping in view the contemporary needs and challenges faced due to globalization. The improvement in the legal education requires a joint action on the part of the bar, bench and the law teachers. Only then we will be able to keep track of the contemporary developments and meet the demands of the future in context of legal education. That's all for today. Thank you so much. Best wishes.